We will call this next case People versus Tate. It's a 15-minute mini oral argument on the application. Mr. Clopton, you may reserve time, but we ask you to keep track of that yourself. And if you are ready, you may begin.
Thank you, Chief Justice. Good morning, Your Honors. May it please the court. My name is Andrew Clopton, and I represent the appellant Tyler Maurice Tate. I intend to reserve 2 minutes for rebuttal. Tyler was convicted of murder on an aiding and abetting theory. He was 16 years old at the time of his offense, and an adult gang member was the one who actually pulled the trigger. Yet Tyler received the statutory maximum sentence of 40 to 60 years. In imposing that sentence, the trial judge failed to adequately consider the extent to which Tyler's offense reflected the distinctive attributes of youth. That was reversible error. To explain why, I'd like to start with this court's first question, whether courts must consider youth's distinctive attributes at sentencing. The answer is yes, for a few different reasons, but the simplest is the reason given in Wines, namely that courts must consider youth's distinctive attributes in applying the Snow factors. And the Milborn proportionality principle requires the same consideration. This court had the inherent and constitutional authority to establish the Snow factors and the proportionality principle in the first place. And despite what the state might have us believe, this court has the same authority now to confirm as a matter of Michigan sentencing law that youth's distinctive attributes fit within these frameworks. And if there were any doubt about that, Article 1, Section 16, which applies more broadly than the Eighth Amendment, resolves it. With respect to this court's second question, courts must consider youth's distinctive attributes on the record in order to fulfill the constitutional guarantees of meaningful appellate review and proportionate sentencing. Even if that is not required in every case, it is required under MCL 769.25 because there are no sentencing guidelines to guide the trial court's discretion. As this court is well aware, the guidelines use more than 24 factors to create a reasonable defendant-specific sentencing range for most offenses. In the absence of guidelines, however, courts must, per Coles, state on the record which criteria were considered and what reasons support the sentence imposed. And per Milborn, sentences under MCL 769.25 must remain reviewable under the proportionality principle. Thus, consistent with ordinary principles of Michigan sentencing law and underlying constitutional guarantees, courts must consider youth's distinctive attributes on the record in sentencing under MCL 769.25. And because the trial court failed to do that here, this court should remand for resentencing. Chief Justice, I'd be happy to take any questions that the court might have.
Thank you. Start with Justice Clement.
Thank you. No questions right now.
Justice Cavanagh.
I don't have any questions right now.
Justice Welch.
No questions.
Mr. Clopton, what if a trial court sentenced a juvenile offender to the 25-year minimum sentence, which is, I believe, the minimum possible, without considering the mitigating characteristics of youth on the record? Would you say that's still inappropriate?
Your Honor, I would say that the trial court should be required to consider youth's distinctive attributes. In that particular case, the state might have an argument that there was harmless error for the failure to consider youth's distinctive attributes. Again, I think that Michigan sentencing law and the Michigan Constitution, as well as the federal Constitution, require consideration of youth's distinctive attributes.
Justice Zahra.
No questions this time, thank you.
Justice Viviano.
No questions.
Justice Bernstein.
No questions.
You have a lot of time, Mr. Clopton. You may continue, and people can just interrupt you, and you may reserve when you would like to.
Thank you, Your Honor. Well, I'd like to address Justice Zahra's question that he raised in Boykin. Nothing in the text or history of MCL 769.25 says that youth's distinctive attributes must not be considered when it comes to the prospect of lengthy term of year sentences. And if it did, that would raise constitutional questions. Moreover, Your Honors, the legislature legislates with background common law principles in mind and evidenced no intent to displace Snow or this court's authority to apply its own case law and play its coordinate role in our constitutional system in superintending courts and sentences. The state would have this court believe that it is powerless to compel consideration of use distinctive attributes because the legislature prescribed a particular procedure in response to Miller for LWOP sentences. That is not the case. It is this court's role to apply its own case, including Snow and its progeny. It is this court's role to, if necessary, interpret the Michigan Constitution. And it is this court's role to ensure that juvenile defendants facing 40 to 60 years in prison have due consideration of their distinctive attributes. And it is this court's role to ensure that defendants have a meaningful opportunity for appellate review, particularly in the absence of sentencing guidelines. And if it were otherwise, then this court was powerless to issue Snow to begin with. It was powerless to issue Milborn, and of course, that's not the case. I would also note, Your Honors, that the approach that we're asking you to take is consistent with the path taken by sister Supreme Courts. For example, the path taken by the Iowa Supreme Court in Knoll, which reached its conclusion independently under the Iowa Constitution. It noted a decision of this court to depart from federal precedent arises from our independent and unfettered authority to interpret the Iowa Constitution. The court there wrote that the prospect of geriatric release, if one is to be afforded the opportunity for release at all, does not provide a meaningful opportunity for a juvenile to demonstrate the maturity and rehabilitation required to obtain release and re-enter society. By way of another example, just 2 days ago, in fact, the New Jersey Supreme Court joined the chorus in companion cases called State versus Comer and State versus Zarate. The court held that a statutory framework for sentencing juveniles, if not addressed, will contravene Article 1, Paragraph 12 of New Jersey's Constitution. That particular framework had subjected a juvenile to 30 years without parole. The New Jersey Supreme Court held that juveniles may petition the court to review their sentence after 20 years, as any lesser period would not comport with the state's constitutional ban on sentences that are the practical equivalent of life without parole. So I would submit that this court should not lag behind its peers, and what we are asking this court to do is hardly novel. Your Honor, unless there's any other questions, I would reserve the rest of my time.
Any additional questions now for Mr. Clopton?
I have one briefly, just in follow-up to what Justice McCormack asked you. What if the sentence was 26 years or 27 years? Does there have to be an articulation of why the judge went a little bit higher than what that lowest range is? Or should there be a presumption that if you're a juvenile, you start at 25 years and then anything above that, there needs to be an articulation of why the judge is going higher than that? So, and the reason I'm asking that is because that would, if you go down to 25 years, then, I don't know that there would need to be an articulation of all of the applicable Miller factors. You would just say, this individual is younger than 18. They start at 25, and then if you're going to go up from there, there has to be an explanation why.
It's a good question, Your Honor. I would say that this court should impose an articulation requirement in all cases because Milborn and the proportionality principle and the lack of guidelines require that. And the rules and polls has never been disturbed because there are no guidelines here. Now, whether the court determined that there was harmless error or something to that effect would be, of course, the Court of Appeals discretion. But I would argue that anything above the minimum articulation should be required as well.
So if we have trial judges that say, this is a juvenile, I'm starting at 25. That's the base, and I'm only going up a little bit. I'm adding 5 years to that because, and then they list a number of factors of why they're increasing, but they're starting at 25 versus, starting at 40 and working their way down. If we're reviewing something like that, I'm asking if that's a framework that our trial court judges, could start from, and if that, tees up these cases for there to be enough articulation of why it's different than a 25-year minimum.
this court could certainly adopt that framework. But again, I would go back to the fact that the proportionality principle is in place. Sentences must remain reviewable under that proportionality principle. And in order to ensure a meaningful opportunity for review, courts need to not only require consideration, but articulation.
Okay. Thank
Mr.
you.
Clopton, can I ask you, so I understand, and I think it was consistent with the defense attorney in the last case as well, of saying that the articulation requirement arises because of the existence of Coles and the lack of guidelines. And Coles said that, yes, you have to articulate enough so that there can be appellate review of the record, but you don't have to articulate. I don't think Coles said you have to articulate a specific thing and each specific factor. So I don't tell me why I'm wrong. In thinking that Coles doesn't actually support a specific factor articulation of the Miller factors.
Well, Your Honor, I read Coles a bit differently. Coles requires courts, and I'll quote it, to state on the record which criteria were considered and what reasons support the sentence imposed. In addition, Your Honor, I would say that the proportionality principle comes to bear as well, and that requires courts to explain why a particular sentence is more appropriate than others. And the problem here is if use distinctive attributes are not considered on the record, and they weren't in this case, and they weren't in Boykin, or at least not in a meaningful way, then defendants will be deprived of any meaningful opportunity at appellate review. And this court needs to, in the absence of guidelines, make sure that defendants have such review. This court has all the authority in the world to, even if Your Honor disagrees with my reading of Coles, this court has the authority to clarify Coles or to extend Coles. Coles falls comfortably within this court's inherent and constitutional authority to place guardrails and to place protections for defendants, and in particular juvenile defendants. And those guardrails are all the more important here, where there are weightier constitutional interests at issue with respect to youth and sentencing.
Okay, and then answer me this. So let's say that we were to agree or hold and instruct the trial courts that they need to consider the attributes of youth as mitigating factors consistent, with our sentencing jurisprudence. What in this particular case with Mr. Tate, what is on the record that would suggest that the trial court did not consider them or didn't consider them as mitigating factors? What's your best support for that factor to suggest that we need to remand it to the court to resentence under that, or at least, So what would that be?
Yes, Your Honor. Well, I would love to have the opportunity to talk about the record. The trial court stated on the record that Tyler was no different than the older adult and more powerful gang figure that pulled the trigger. And the trial court noted further that in our civilized society, your actions, despite your age, do not make your actions forgivable. And it labeled him a deplorable and said that Tyler had ruined his own life by his own design. In other words, I would say, Your Honor, that the record is actually worse than silent. It evidences at best a misunderstanding and at worst a conscious disregard of youth's distinctive attributes. Now, to be fair to the trial court, it did not have the benefit of fines, but that is all the more reason for remand in this particular case. Second, Your Honor, I would note that the trial court sentenced Tyler to the statutory maximum under 769.259. And that further evidences that despite the fact that Tyler neither masterminded nor committed the murder, the trial court gave no weight whatsoever to any mitigating qualities of youth.
Okay, thank you.
Thank you, Your Honor.
Would you like to reserve 45 seconds, Mr. Clopton?
Yes, Your Honor. Thank you.
Ms. Smith.
Good morning, and may it please the court. Amanda Morris Smith, Wayne County Prosecutor's Office, on behalf of the people of the state of Michigan, the appellee in this matter. The primary issue before you this morning is whether the Court of Appeals correctly decided People versus Wines, and it did not. In Wines, the court held that the sentencing judge must consider the distinctive attributes of youth, such as those described in Miller, when sentencing a minor to a term of years for first-degree murder, and that a judge's failure to do so constitutes an abuse of discretion and reversible error. But as the court acknowledged, its holding was not compelled by the Constitution. And the Wines court seemed to acknowledge that its holding was not supported by the plain language of the statute, as neither MCL 76925A or 76925 impose such a requirement on trial court judges. And as two justices of this court observed in 2020, extending Miller into a term of years sentencing hearing lacks any warrant in any previous decision of this court. Under separation of powers principles, if trial court judges are going to be required to expressly consider and apply Miller factors or something similar at a term of year sentencing hearing, the Michigan legislature should be the one to say so. And I'm just going to add, because I was watching the previous argument on a delay on YouTube, I fully endorse everything Jim Bennison said in his opening. I thought it was fantastic. So I'll incorporate that by reference. And with that, I want to get to any questions the court has before moving into my argument. So I'll waive my remaining free fire.
Thank you, Ms. Smith. Justice Clement.
No questions. Thank you.
Justice Cavanagh.
No questions right now. Thanks.
Justice Welch.
I actually do have one, Ms. Morris-Smith. Similar to what I asked Mr. Bennison, I'm wondering, what are we supposed to do if we get a record where it seems to show that youth was more of an aggravating factor than a mitigating factor? I know Mr. Bennison spoke at length about the length of the record in his case, but I'm wondering what your thoughts are on that.
Sure. And I think that question incorporates something that Justice Cavanagh was probing Jim Bennison about during his argument. And it really goes back to the two foundational principles of Miller. That case was supported by two lines of U.S. Supreme Court precedent, one of them being a line of death penalty cases and the procedure that provides guardrails for death penalty cases. And in death penalty cases, the court has said that trial courts have to have a completely open door when death penalty is on the table. They have to completely make available to the defendant the opportunity to present any and all evidence of mitigation, and the trial court cannot refuse to consider it. It cannot refuse to consider it by giving it no weight. And that was what happened in Eddings. The trial court judge heard evidence about the defender's background and said, I will not consider that for purposes of sentencing. And SCOTUS says you can't do that. Now, the weight the trial court judge gives any of the Miller factors, and in Skinner, this court said all Miller factors are mitigating. The weight that the trial court judge gives the mitigating factors is completely within the trial court's discretion. I suppose there could be a set of circumstances where the trial court judge makes certain statements on the record, and on appeal, it's claimed that there was clear error. But other than that, we trust trial court judges to give weight to the Miller factors, and perhaps as case by case, some factors would be weighted more highly than others, but the judge still makes that evaluation as part of the sentencing process.
Okay, thank you.
Thank you.
Justice Zahra.
Thanks. There's been a lot of questions asked of counsel in both cases about the guidance that we could provide to trial courts. If we were to agree with you that Wines was incorrectly decided, do we need to give guidance beyond saying that? In other words, would it be enough to say trial courts are guided by traditional objectives of sentencing and principles of proportionality? Wines was wrong to say Miller factors apply in term of years, and trial courts go do your business. Or do we need to do more?
So this procedural posture of this particular case is a little bit odd, I guess. As the prosecutor, I'm saying Wines was wrongly decided, but I'm the appellee. So an order denying leave, I feel like doesn't really accomplish the goal that I have, which is at a minimum, if you're going to keep Wines, we need to clean it up. But I agree with you, Justice Zahra, that this court could issue an opinion and order saying the Court of Appeals in Wines went too far. And it went too far because it didn't just say trial courts, you should consider the Miller factors or something similar, because that is language it used. It said, if you don't consider it, we will reverse you and send the case back for resentencing. And in my exhaustive research of this court's precedent, that's really a bridge too far. Court of Appeals cases going back many decades have refused to reverse a trial court sentence just because the court failed to mention a particular mitigating factor or snow factor on the record. So I agree with you, the court could do an opinion saying Wines went too far. The trial courts just need to do what they've always been told to do. Consider the background of the offender, the seriousness of the offense. You can consider the snow factors, but even in Snow and Coles, this court said those are not exhaustive. And the failure to mention one of them does not make the entire sentence invalid. So you could kind of ball up all those different lines of precedent and just throw it back to the trial court judges. Or if this court was more inclined to keep Snow, I do think we have to address some of the questions that were brought up in the last argument about what does Snow really mean? What are we actually asking trial court judges to do? I can explore that more once we get through everyone's questions. So I think there is something there.
Thank you.
Justice Viviano,
No questions.
Justice Bernstein.
Counsel, good morning. I just want to ask a practical question because that's just what I'm kind of focusing in on right now for this specific case. What are the concerns of the state? What are the implications of this decision that you are concerned about?
So for me, the number one thing is this court is the one that asked the question, was Wines correctly decided? So I'm here to tell you, I don't think so. And here are 3 reasons why. So I'm interested in the, published opinions of the court. So the Court of Appeals opinion in Wines is published, that it accurately reflects the state of the law. And I don't think it does for the huge amount of reasons I said in my brief.
Right.
But
I understand that.
Secondarily,
what I'm trying to get to is what are the real, what takes this out of the academic and makes this, that what is it that prosecutors are concerned about as it pertains to this, as it pertains to kind of their day-to-day activities in the courts?
Sure. And some of this, because on the Zoom delay, I don't know how much they got into it in Boykin, but this is the concern. So if we're going to keep Wines as it is, and it says the trial court has to consider and apply the Miller factors at a term of year sentencing hearing. So number one, what does that actually mean? As Justice Markman pointed out in his partial dissent in the order denying leave in Wines, it's not really clear what we're asking the trial court judges to do. So one, the state is concerned with when we're there for sentencing, we want to understand what are we needing the judge to do so that we have a proper sentencing that affords the defendant all of the rights that he's entitled to so that we don't get reversed and remanded for a new sentencing hearing, another time around and put the victim who has constitutional rights under the Michigan Constitution through a secondary sentencing hearing. I think what also was brought up in the prior argument is that some defense attorneys read Wines to mean that the defendant in a term of year sentencing hearing is entitled to a Miller hearing. Well, that's a lot. Those are extremely intense hearings. They require experts. There's an entire line of guidance given to capital defense attorneys as to how to properly represent a defendant in such a proceeding. If a defense counsel doesn't make certain arguments, doesn't get an expert.
I guess my question is what I'm trying to really gather is, I understand. I think I'm getting this. What I'm trying to understand is that what I'm trying to gather just from a practical, pragmatic kind of day-to-day in the courtroom circumstance, is that burdensome? I mean, in terms of having to go through that, is that highly burdensome for the prosecutors?
To have every term of year sentencing hearing turn into a Miller hearing?
Yeah.
Yes. I mean, they're lengthy hearings. And like I said, they require experts. There's ineffective assistance of counsel claims coming out of those hearings, all day, every day. And they're time consuming and costly. Of course, if it's required under the Constitution, because we're talking about defendant's fundamental right, then I'm all for giving defendants what they're entitled to. But, circling back to the primary contention running throughout the brief is that there is just no 8th Amendment or Michigan constitutional requirement that we have this type of mandatory
But what I'm trying to gather is that just what I'm trying to understand, and this is my last question, as I'm weighing this, is that the main issue? Is and again, I'm just trying to gather this. it's the length and the scope. And I mean, is it the burdensome nature of it? Is it that is what it really comes down to as to why the state is concerned?
It's just, why are we requiring that when it's not required under the statute, the Constitution, or any previous decision of this court? If the Michigan legislature wants to put that on trial court judges for this type of proceeding, they're welcome to do so, but they haven't said so. So I guess I struggle to understand why we're requiring this process when there's no support for it in the law, given that it is a very in-depth process.
Okay, counsel, thank you so much.
Thank you.
Ms. Smith, can I ask you a question? I want to go back to the point that and I think it's an interesting concept to think about, that mitigation, or these factors as mitigation, the age as mitigation, is really sort of a question of weight, right? That the trial court is, or the sentencing court is looking at. So, and we review that for an abuse of discretion. So, for example, in this case, him saying or suggesting, or the trial court suggesting that he, even though he was, under 18, he was no different than the adult shooter in this case. And that's, that's him weighing the age. Is it an abuse of discretion if there isn't something in the record that actually supports that conclusion? I mean, is it enough for him to say, it's just my opinion that he's no different than the adult shooter, if there isn't something in the record that actually suggests, actually this 16-year-old actually is of advanced intelligence and maturity and this sort of thing? He actually, there is something that would support that despite his age, he actually is the equivalent to an adult. And if there isn't something like that, and it's just, is that an abuse of discretion on something like age, of saying, I know that maybe there's science out there, whatever, but in my opinion, a 16-year-old is no different than a 22-year-old shooter.
Right. And I think part of the difficulty might be is you could interpret Judge Cox's comments, I think, two different ways. One is the way that you're describing, that Mr. Tate's chronological age was no different than, the trigger man's chronological age, 16 versus 18. Or you can interpret Judge Cox as saying that, the moral culpability of what Mr. Tate did in this case is really no different than what the shooter did in this case, that he didn't find that the actual concerted activity made Mr. Tate less blameworthy or less culpable than the shooter. But
that's the moral culpability is a factual question about the facts of the crime, right? It's not an attribute of youth. It doesn't change a 16-year-old into an 18-year-old, does it?
Well, as far as moral culpability, I know that's something that's come up in many different SCOTUS opinions. I think Graham, Roper, and even Miller touch on that, as far as weighing the relative actions of each of the parties in the case, looking at the totality of the crime, and then looking at the Miller considerations. I also just want to hop back, though, very quickly. Something that I think hasn't been emphasized enough is that Miller just requires a discretionary process. When you give the discretionary process to the defendant, as was done in this case, Jones versus Mississippi says defendant got what he's entitled to under Miller. So again, appellate courts don't tell trial courts how to weigh mitigating factors and how much weight to give to each of the things that may be presented by a defense attorney and defense counsel for purposes of requesting, a lower sentence, as defense counsel did in this case. And he invoked Mr. Tate's youth and attendant attributes in requesting a 25-year minimum sentence for Mr. Tate.
Okay, thank you.
Were there any other?
27 seconds, Ms. Smith. I don't see any additional questions.
So I want to bring it home by emphasizing a point that I made in my brief. The people are not arguing that youth and its attendant circumstances are irrelevant. Defendant under Miller is more than welcome and is able to bring all of that evidence to the trial court attention. Trial court can't say it refuses to consider it. It must consider all the evidence brought to it, but then it's left with the discretion to give the weight that evidence is entitled to. And for these reasons, we'd ask the court to deny leave in this case, but also clarify the scope of wines. Thank you very much.
Thank you, Ms. Smith. Mr. Clopton, you have 43 seconds.
Thank you, Your Honors. Just one point. We aren't asking for a new process, and this just isn't that big of a burden. We're asking you to require trial courts to consider the attributes of youth and explain how they factor into the sentence. Trial courts do that sort of thing all the time anyway, and always have to explain their reasons. They are more than capable of doing that with respect to youth. But we can't lose sight of the fact that the articulation requirement is heightened here because there are no guidelines to ensure a meaningful opportunity of appellate review. Thank you, Your Honors.
Thank you very much. The case will be submitted. We appreciate both of your arguments.